All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good morning. Welcome to your North Carolina Court of Appeals. I'll be presiding today. My name is Judge Chris Dillon. To my right is Judge Allegra Collins, and to my left is Judge April Wood. We have one case on the calendar. It's interesting. I know you have this clock in front of you, but I don't pay attention. I'll kind of give you warning when you're coming up, so don't let that distract you. So I don't know if it's going to be on or not. But tell me, we'll hear from the appellant first, so you can go ahead and approach the podium. But let me know if you reserve any time for rebuttal. And you'll have 30 minutes total.
Honor. I would like to reserve 5 minutes for rebuttal.
Perfect. Okay. You can proceed.
May it please the court. My name is Amanda Zimmer. I'm an assistant appellate defender, and I represent the juvenile in this case. As I said, I'd like to reserve 5 minutes for rebuttal. We are here today because of conversations between an 11-year-old and her classmates, which led to adjudications for a misdemeanor and a felony. During these conversations, Sophie was allegedly talking about bombing the school, or saying she was going to blow up the school, and saying something about hitting a classmate over a crowbar. Recognized in Bishop. Under the First Amendment, society must tolerate some speech and conduct, even when we do not approve of the behavior. Because the state to produce sufficient evidence that the speech at issue here was unprotected, both adjudications should be vacated. We plan to address two of the issues raised. First, whether there was sufficient evidence to support the adjudication for the felony of communicating a threat of mass violence on educational property. And second, whether there was sufficient evidence to support the adjudication for misdemeanor communicating a threat. I plan to start by talking about what I think the state and the juvenile agree on, and then talk about the nature of threats and the test for proving a true threat, and then talk about how that applies to the two offenses at issue here today. So turning to what I think the state and I agree on, and I'm sure they'll correct me if I'm wrong. First, North Carolina General Statute 14-277.1 and 14-277.6, the statutes at issue here, content-based restrictions on speech. As such, they're presumably invalid. Since threat is not defined by either of these statutes, to serve a constitutional challenge, the threat element must be construed to cover only true threats. Under Virginia versus Black, true threats are those statements made where the speaker means to communicate a serious expression of an intent to commit an unlawful act of violence against a particular individual or group of individuals. Under this court's decision in State versus Zimmer, a true threat exists only when there's both a general intent element and a specific intent element proven.
Would it be a true threat or no intent to get out and they were joking, but they wanted the hearer to believe them? Like, I want to play a trick on them. I want them to believe that I'm going to blow up the school. I'm not saying that's what happened. Is that enough for it to be a true threat?
Under Taylor, there has to be a serious expression of an intent to convey a threat and make the listener believe it will be carried out.
So it doesn't matter that whether she had the actual intent or not, as long as she intended that or said it in a way that...
Right, and I think that comes from the United States Supreme Court law in this context, that even if there's not an intention to carry out the threat, if a reasonable person would believe it and the speaker intended it as a threat, then it's not a joke, it's not idle talk, and at that point it is something that is punishable.
Yeah, as long as the speaker understood her speech to be understood as a threat by the receiver. Okay.
I believe that's the test under Taylor at this time. And the last thing I want to talk about briefly that I think we agree about is that it's critical to consider the context and the manner in which the threat was made when discussing whether or not a threat is a true threat. Finally, there's one more point where I do think we will agree, and that's that preventing violence in our schools is a legitimate government aim. I think we just disagree about how it should be dealt with. Here, we have a felony at issue, which was enacted following a number of school shootings, communicating a threat of mass violence on educational property. Schools and parents can certainly discipline a child for bad behavior, improper comments, and bullying. And the school did punish Sophie here. She was suspended and then expelled. But what can't happen is that the criminal law can't step in here because the speech was protected in the absence of evidence that violence may occur or was likely to occur.
So when she said that she was going to blow up the school and shoot everybody, you contend that she didn't actually mean it, or she didn't have the means to carry it out?
Your Honor, I think both of those things are relevant to assessing whether or not this was a true threat. I'm going to forward a little bit because not all threats are true threats, but some can be considered are certainly the speaker's ability to carry out the threat and whether or not they mean to. Her threats here were vague. There was no evidence of any capacity to carry out the threat. No plan on her part, testimony. There was no plans found in her emails.
So the state's got to prove that she's got the ability to do it, or just that the person that receives it might think? Because if I point a gun at you and it's empty, I think that's a true threat, because I'm intended it, but I have no ability. Does the state have to prove that? Do they lose because there's no bullet in the gun?
No, Your Honor, I don't think they do, because a reasonable person receiving that threat would be justified in thinking that the gun was loaded when you're pointing
So they don't
at.
have to prove that she had the ability, but just that a reasonable person may think that she has the ability.
Yes, I don't think they have to prove there is an ability, but that certainly is something that they can consider. Obviously, when they had searched Sophie's emails, they had found plans for the bomb. That would be very relevant, because it would be part of the threat, but here they didn't. They didn't find anything in her email to suggest that there was a threat against the school or that there was any plan to build a bomb.
How does her age play into this? I think she's 11, and those receiving a lot of these threats or communications were 11. How does that factor into this?
I think that's sort of an open question. I think it's a huge factor in how it would be received. Again, we're talking about a reasonable person standard, and in doing that, I think we look at this from a reasonable adult perspective. 11-year-olds say a lot of things. They say something mean, they say some things that are crazy, but certainly the age of the speaker has to be a factor that is considered. And in re DWLB, this court did consider the age of the reporter in that case when discussing a statute that was enacted at the same time, North Carolina General Statute 14-277.5 for a false report of a threat of mass violence. And there was definitely a question of age school student reporting a threat. It was probably not credible to a reasonable person. So I think both when it comes to a reasonable person standard, age is very relevant because we know children
Is that
don't.
for both charges? Because I could understand that for communicating a threat that you're going to blow up a school, that should be, the intent of that is it a serious threat that an adult would think? But the communicating threat to another individual, is what it's just getting at? You don't want to put anybody in apprehension of fear. Should that crime at least be viewed in what the age of the receiver? I mean, what a reasonable child would think. Would they feel threatened?
Your Honor, I think the age is still relevant. For communicating a threat, the statute specifically an element of belief by the person threatened and also what a reasonable person would think. Where the statute is lacking is it still doesn't account for the intent of the speaker as discussed in Taylor. So in communicating a threat, I think both for whether or not the person receiving the threat, who here was old, and for a reasonable person standard as required under the statute, I think the age of the speaker and the age of the recipient are certainly relevant.
But you would certainly concede, though, that even elementary school children have had access to firearms and have been convicted of bringing things like that to school, and children have committed murder.
I would admit that those things.
So just the age itself might not be the most important factor.
I'm not suggesting that, no, it's in fact an important factor. I don't think any one factor is necessarily the most important because this court has to look at it in the full context of how the threat was communicated, how it was received. So I think it's a factor. So turning back to sort of the nature of true threats, and one of the things that I think is important for talking about why they're not protected under the First Amendment is that because true threats are those that are generally considered to be of such a clearly threatening nature that their criminalization is not prohibited by the First Amendment, even though they're expressive, even though they are expressive in nature. As this court stated, in threats that amount to nothing more than just idle talk or political hyperbole are protected by the First Amendment. And that's because the government obviously has a right to protect the public from lawless conduct. And when there's a possibility that a threat is going to clearly and eminently into conduct, then the government has the right to step in and prohibit it. Otherwise, freedom of speech is only subject to restriction when there's a grave and immediate danger to interests which the state which lawfully protect, just protecting people from conduct. Just under this court's decision in Taylor is that there both be a general intent element and a specific intent element.
So the quote here is that the defendant intended that. What do we look at to determine whether the defendant intended so?
I think we look at the same factors that we look at considering whether a reasonable person would have believed the threat. I think this is a confusing part. We know that we don't just look at what the speaker said, we have to look beyond that. So I think here we look at what was said, the plain language. We certainly look at Sophie's explanation of the other students and their reactions. We look at the relationship between the speaker and the receiver of the comment. Because obviously if you walk up to somebody with a gun who doesn't know you and you point it at them and you threaten them, they're going to receive it as a threat. They don't know you, you don't have any history. If we look at INRI SRS, which was a case from this court dealing with a juvenile threatening a teacher, they considered that this juvenile had threatened the teacher's daughters before and that there had been physical violence at issue. So we certainly look at the relationship between the parties when talking about intent, because somebody who has a history of violent acts against someone, that threat is received by that person much differently than somebody who are friendly and have no history of hostility.
So the fact that she has made sort of threats over a period of time, but anything, is that something that we look at?
Your Honor, I think it is something that we look at, and I also think what we have here is, if I'm reading the record correctly, about a 2-week period of mean comments between Sophie about Cameron. What Cameron testified that he remembered Sophie saying to her was him a nerd and calling him a failed abortion. I agree that these things are not appropriate, but they're not really threats. The only other thing that he was potentially a threat, and I don't think anyone thought it or a true threat, was that he would find the grave of an Ebola victim, dig it up, and push him in so he would get Ebola and die. And I think when you're looking at that kind of fantastical, unrealistic threat, that's a history that shows she intended this threat to be taken seriously and that she intended him to be placed in fear, that she was going to get a crowbar and hit him over the head with it.
Didn't Cameron testify that he heard her tell someone that she was going to hit him with a crowbar, and then she admitted that to the assistant principal later, saying she was so angry she wanted him to die, she wanted to hit him over the head with a crowbar?
Yes, Your Honor. He did that he overheard her saying, and she gave sort of different versions to the vice principal about why she said that. First, she said she was talking about movies, serial killers, and then she said she became so angry she just said she was going to hit him over the head. And again, statements in anger, that's certainly a factor you can consider when deciding if this is a true threat, if it was just her spouting off because she was annoyed by a classmate she disliked.
What did she say to Cameron that was bad? Because I'm reading the statute, and the statute says that he willfully threatens the other person and says it to the other person. So
Right.
So is there evidence that she said something in a way that he overheard it, or is that? I'm just trying to look at, because we don't reweigh the evidence. I'm trying to figure out, in the light most favorable to the state, what does the evidence show?
Right, in the light most favorable to the state, Cameron's testimony was that they were sitting at the same table at lunch. I don't know how long the table was, that's not in the record. And he was sitting at one end of the table talking to friends, and she was sitting at the other end of the table, and he overheard her say she was going to hit him over the head with a crowbar and bury him in a shallow grave. And when he was asked upon the context in which that statement was made, he says simply, she said she was going to do that, and then proceeds to talk about the Ebola incident. So in the light most favorable to the state, I believe there's evidence that she said it in a manner where he could overhear it.
Okay.
And the only other witness, Madison, who testified about the crowbar, she was very when it happened or any surrounding circumstances. Taking Cameron's testimony, that's enough to show that it was communicated in a manner where he could have overheard it.
The emails found where she said she wanted him to die the most brutal death, kill him with his fingers, shove Bibles down his throat with her penis, lean on him, light him on fire, save his home, save his bones, and give it to his family. Who were those emails directed to?
Your Honor, the record does not reflect that. Okay. It said that these are emails she sent from her personal account. There were emails between friends, but it's not clear. Literally, as you just read it, is how it came in the school resource officer's testimony, so these comments really have no context. So there's nothing threatening to Cameron in her email, so the emails were not sent to him.
Thank you.
So why do you argue that those statements to the crime of communicating a threat to another person, these crimes individually? So that crime, why do you think that this is at least to go to a fact finder to say that he committed this crime? And I guess part of your argument is it a true threat? So, I mean, be specific. How is this not a violation of this statute?
So we're talking just to clarify.
277.1 said to, in Cameron's hearing, I'm going to beat him over the head with a crowbar.
Right, because I believe two elements are not met. I believe that a reasonable person hearing this comment would not have believed this was a threat. And I also believe that Cameron didn't really believe that she was likely to carry out this threat. In the light most favorable to the state, we have a comment at lunch among 11-year-olds. A reasonable person hearing this could see that Sophie, considering the full context, Sophie didn't have a crowbar. She wasn't coming at Cameron. They weren't engaged in some sort of argument. She had no history of violence. This, in context, I simply don't believe a reasonable person could believe this was a threat under the statute's language or certainly under the true threat doctrine of the First Amendment.
So what we've got to decide is whether or not there was enough evidence from which a fact finder could conclude otherwise.
Right, and I think then this court also has to conduct the whole record review under Desmond, sort of double check to make sure that there's not a violation of the First Amendment. So looking at the statutory elements, I contend those aren't met. And then I contend that the constitutional elements of a true threat. And when looking at the whole record, this court considers the full context. And I think this is important here because I think at that point, you can also consider Sophie's testimony. Sophie's testimony about the crowbar is confusing. The vice principal's evidence is confusing. Sophie, there's nothing here in this whole record to support that Sophie intended Cameron to hear her if she made it, or that she intended it to be taken seriously. So we still have a sense of on her intent, which we have to show under Taylor. The state had to show under Taylor.
The fact that she said it loud enough for somebody to hear it, can't a fact finder say she intended it, notwithstanding the fact that she denies it, because they can just disbelieve her testimony?
Well, Your Honor, I think that there's a difference between intending to say something and intending it as an actual threat. She is 11. This is fantastical. This is sort of a thing that she saw on TV. She told the principal this is something that was being discussed in the context of movies, or that someone else had said it, and she was repeating it, kind of thing. So I think just the fact that he heard her show that she intended him to believe it, intended him to receive it as a threat, that she was going to, in fact, carry this out, whether or not she actually was going to carry it out.
Didn't Sophie actually? wanted Cameron to die and that she did make those threats?
She testified that she didn't want him to die. She said she wished he was dead. She did not at any point admit to the threats themselves. She mostly denied that she said it, or she said she wasn't serious. She was joking. And I think there's a difference between an 11-year-old saying they want someone dead and an 11-year-old planning to kill someone or to hit them or to injure them. So her dislike, and that's okay. She could dislike him and could say mean things to him. The First Amendment allows her to do that. It's only when it crosses into an unprotected class of speech that she can be punished for being a delinquent juvenile, and we just didn't cross that line here. What we have is idle talk and jokes. Bad jokes. Nevertheless, not conduct that's punishable.
What was the worst thing she said about blowing up the school in the light most favorable to the state?
Your Honor, in the light most favorable to the state, I believe the said that was most damaging was she was going to douse the school and blow it up. And that was something that the vice principal said that she said. And it was unclear from his testimony if he was talking about talking in a vague way or threatening to blow up the school. The actual comments from the juveniles that heard the threat were that she was talking about bombing the school, talking about blowing up the school, maybe talking about using gasoline, though Tyler specifically denied that, and I'm not sure who else was asked about the gasoline comment. I think it's worth pointing out that the testimony in this case is limited. It's also testimony from 11-year-olds, and there's a lot of leading questions. So a lot of the statements that come in are in the form of the district attorney saying, did you hear bombing the school? And the witness says yes. And that's all we have. So in the light most favorable to the state, she said something about blowing up the school or something about bombing the school. So I just want to touch on one other factor that I think is really important here, both for the communicating a threat and the communicating mass violence, and that's the reaction of the listeners. Here, the listeners to Sophie's comments about the school were other 11-year-olds, and none of those people that heard it directly went to a teacher. It was only when the comments were repeated to another student that it appears to have been reported. So no one took this seriously. Even Tyler offered to build a bomb for her, and nobody reacted. From what I can tell, nothing has happened to Tyler. There was no petitions against him for saying he was going to build the bomb. The school resource officer did become involved, but he didn't say that there was any kind of lockdown. He didn't say there were any bomb-sniffing dogs brought in. There was no reaction from law enforcement that suggested that they were taking this as a very serious threat against the students at the school. Even the vice principal sort of says that he interviewed Sophie once and sent her back to class. It seems like that's what happened while he interviewed other students. And then she comes back. At no time is there anything in the record to suggest that Sophie and Cameron were separated, that they were keeping her away from him because they thought he was in danger from her. And I think in light of the fact that these are 11-year-olds and that this was during the school day and things were very vague, this just wasn't taken seriously by anyone. And I think that's something that this court should consider in deciding if this was a true threat. Because if the people in the moment they didn't believe her, they didn't believe she intended it, they didn't believe that there was a danger. So
you're saying there's an objective that she needed to intend, they have to prove that she intended for it to be taken seriously and that the receiver subjectively took it seriously.
Objectively took it seriously. So a reasonable person, so she had to subjectively intend that it be taken seriously, and then a reasonable person had to, objectively looking at the situation, had to believe that it was a serious threat.
But whether the receiver actually believed it or not is irrelevant. There's no subjective on the receiving end as well. Would you argue?
For communicating a threat of mass violence, I believe that the statute doesn't require that. For communicating a threat, the misdemeanor, there is a statute element that requires So this is where it's odd that the misdemeanor actually provides more elements than the felony.
And you have 2 minutes before you eat into your 5.
And I'm just going to wrap up then. We protect speech for its own sake. This case involves policing conversations between children. Our Supreme Court has recognized that civility, whose definition is a laudable, not one readily enforced laws. This is especially true when we're trying to enforce criminal laws against children. Children are not merely miniature adults who fully understand the consequences of their words or actions. Our courts have long recognized their special status because of their inherent immaturity. The age at which children should even be subjected to criminal law is a matter of debate. The legislature just raised it to 10. The attorney has said it should be 12. Here, Sophie was 11. She said inappropriate things. She said mean things to her classmates, and no one's disputing that. But these things were protected by the First Amendment. She did not make a truth threat against Camp.
These went on for a period of weeks, right? And wouldn't you kind of consider that if she said it over and over again, how she wanted him dead, she wanted to kill him, wouldn't you consider?
Your Honor, it very well could be considered bullying. Bullying is not a crime because a lot of this conduct is protected by the First Amendment. And certainly, the school could have disciplined her for her, and so could her parents. But the criminal law couldn't step in here to forbid this conduct. So for the reasons argued here and in the brief, Sophie requests that this court vacate her adjudications. Thank you.
Thank you. And you still got your 5 minutes.
Thank you.
We're here from the state.
Thank you, Your Honors. Good afternoon. Tiffany Lucas from the Attorney General's Office on behalf of the state. May it please the court. Your Honors, as an initial matter, Sophie's or the juvenile's attempts to characterize her statements as mere baseless jokes or inappropriate or mean comments should be disregarded by this court. The evidence in the case allowed the trial court to reasonably infer that Sophie's statements about blowing up the school were beyond mere harmless jokes. Furthermore, Your Honors, in an era of school violence, teachers and administrators must take all such jokes seriously to ensure student safety. The suggestion that such jokes about mass violence be allowed even when these so-called jokes include a specific statement that mass violence is going to occur on a school campus would hamstring school officials in responding appropriately to serious threats of violence.
So let me just ask, you just said that we must take all jokes seriously in this era of are you suggesting a per se test that is some sort of statement of violence that ought to, that's criminal behavior?
No, I'm not suggesting that any joke about mass violence is necessarily criminal, but it has to be examined as be compared to the test for under the statute to determine whether, in fact, it is criminal conduct. And in this case, Your Honors, I would argue that certainly there was sufficient evidence for the trial court to determine that there was sufficient evidence that this is criminal behavior. The juvenile argues that the state did not present sufficient evidence of threat under really two statutes. We're talking about two statutes, and we're really talking about two sets of statements. The first one that I will discuss is General Statute 14-277.6. Is the statute defining violence on educational property. Of course, as the court is well aware, in an appeal raising an insufficiency of evidence claim, the evidence is considered in the light most favorable to the state. The state is entitled to every reasonable inference that may be drawn from the evidence, and unless favorable to the state. Furthermore, contradictions and discrepancies are resolved in favor of the state. So turning to the language of the statute, in relevant part, the statute states that any person who by any means of communications threatens to commit an act of mass violence on educational property is guilty of this felony. And the communication at issue here is the statement by Sophie that she would douse the school in gasoline and blow it up. Now, Your Honors, there's been much discussion about whether an objective test applies, whether a subjective test applies, or whether both apply. And as the court is well aware, that this court held in the Taylor case that both tests apply. From the Ninth Circuit Court of Appeals, this court held that both tests apply. Your Honor.
So what does that mean? What does the state have to prove?
So
subjectively, she meant it?
So on the objective side, that a reasonable person would believe that this threat was likely to be carried out.
So the receiver would reasonably believe, okay.
And an objectively reasonable person, yes. And then on the subjective slash specific,
is that a reasonable adult for this statute?
Your Honor, I know that is clear. I think that there is room to consider of the receiver as well as the age of the speaker of the threat. But in terms of what a reasonable person, I think you can take into consideration the age of the receiver of the threat. And then on the subjective slash specific.
So you think the statute's trying to get out? The way I read it is like communicating threats trying to just stop is what an adult administrator would think. Is this really reasonable? Not whether another 8-year-old or 10-year-old thinks that someone's going to really blow up. That is what this statute's getting at. But move on to the second one. Tell me about this.
The subjective specific intent part of the test under this court's holding requires that the speaker of the threat intended that the statement or threat would be received as such by the listener. And Your Honor, the state contends that there was sufficient evidence presented that both parts of both tests were met in this matter. The statements that Sophie made about dousing the school in gasoline and blowing it up satisfy both the objective test for being a threat and the subjective part of the test. And Your Honor, I think you have to look at the statements that were made in context.
So what was the evidence that, in the light most favorable to the state, what was the worst thing she said? Because I know there was some talk that the principal testified that somebody didn't consider that. I mean, would that be, what's the evidence that you think is most damning to this juvenile? The thing that she said that was, you think constitutes the commission of this crime?
The most damaging evidence to the juvenile in this case is her admission. She did say that she was going to blow up the school. She said that at the adjudication hearing. She said it previously in her statement to the administrator at the school during the investigation of this matter. But at the adjudication hearing, she did testify that she made these statements. Now, after the fact, she testimony and there were from the assistant principal about contradictory statements she gave. She testified at one point that she made the statements in anger or that she intended them as a joke. But there is no question that the juvenile testified that she did make the statements about blowing up the school.
I'm just trying to figure out, so this objective test, and we're talking about an 11-year-old getting a gas canister from somewhere, getting gas in the canister, getting the canister from wherever she got it to the school. It seems, perhaps from from some points of view, wholly unreal. So whose objective view is this? I mean, is this the trial court's objective view? Is this the principal's objective view? Is this the 11-year-old's objective view? That seems like a tall task to carry out for an 11-year-old.
Your Honor, I respectfully disagree that this is an unlikely thing that could happen, even when we're talking about middle school age students. Particularly, look at the full context of the record. We're talking about an 11-year-old who was much larger than some of the other students in this that are relevant to this matter. We are not talking about a small child. We are talking about an 11-year-old middle school age student who had been making comments for weeks, suggesting that she was having violent fantasies, violent thoughts, hurting people, about committing acts of violence and injury.
Did she say, I'm going to blow up the school, or did she say it wouldn't be cool if somebody blew up the school? How did she say it?
In the light most favorable to the state, the evidence is that she said she was going to blow up the school.
And I want to ask you a quick question about the standard review, because normally in a jury trial, the judge explains the law to the jury. So if the jury's not the law correctly, even though their evidence might have supported a verdict, we might send it back for a new trial. Was there an argument made about these tests as subjective and objective to the trial court judge? And is there any indication that what standard the trial court judge actually applied in coming to the decision?
I believe that the record reflects that there was argument made to the trial court judge about whether an objective and or subjective test applied, and that is captured in the jury dismiss.
So there's no question that the judge in the judge's mind that the standard that the judge apply.
I do not think the record reflects that there was any question in the trial court's mind. No, Your Honor, and that certainly was not raised.
Okay.
And, Your Honor, the other evidence in the record that is damaging to the juvenile is the assistant principal's notes, his investigative notes that he took in very close proximity to the time that this was all happening, or when he learned that the threat of mass violence on the school property was made. So the record reflects that upon learning of this, so there were several listeners who heard the juvenile statement about blowing up the school. And although the juvenile takes great pains to point out that there are slight discrepancies in the the student's testimony at the adjudication hearing, we have to remember that this event happened in September of 2019, and then some 11 months later, these 11 and 12-year-old students are at an adjudication hearing recalling what happened almost a year ago. And even though their don't completely align, almost to a T, they all mention that there were these statements about a bomb or the school being blown up. And then the assistant principal's notes taken contemporaneously with the events that happened reflect that those students mentioned that Sophie had made comments about blowing up the school or about there being a bomb at the school, as well as some other violent comments.
Why would that be admissible? Because he didn't see it. He or she wasn't taking notes, observing it. It was just what somebody might have told. I don't know if it was a male or female, told him at that time. Why is that admissible?
Where the his investigative, they go to what was done and whether what the was when the statements were made. And Your Honor, the juvenile has argued that no one took these threats seriously, but the state admits that that's absolutely not supported by the record. The assistant learned that there had been a threat made, and investigation ensued.
Does that matter? Because I didn't think it subjectively mattered what they thought. It's just whether an objective person would think. So there's no subjective on how it was actually received. I thought it's just objectively how a reasonable person would receive it. Maybe that's some evidence as to whether or not an objective person is how the receiver actually. That would be some evidence.
I think that's right. I think the schools, the administrators, the listeners, the people who learned that the threat had been made, I think that is relevant to whether the threat made to the hearers of the threat took it seriously and whether it was reasonable for the hearers, the persons who heard it directly, whether it was reasonable for them to have taken it seriously. So I think all of that is relevant. So if you look at the assistant principal's notes, which are in the record, there's some mention during the interview with Sophie that at some point during the interview, she admitted that she made the statement to blow up the school, or that the school was going to Friday because it was a joke. Now, this incident happened on a Wednesday or a Thursday. And so the fact that immediately the school investigated this, got law enforcement involved, had law enforcement look through Sophie's text and emails and other social media to try to determine whether there was more there, is a perfectly reasonable response to an alleged threat that something was going to happen 2 days later at the school. So it is not as if the school administration and law enforcement did nothing in response to having heard that there was a threat that 2 days later Sophie intended to blow up the school. And Judge Collins, I want to make sure I responded fully to your question about whether this is completely fantastical or outside of the realm of possibility or likely possibility. Again, the law does not require that Sophie have articulated the full plan for executing blowing up the school. It is enough that she said she was going to commit this act, and when you look at the full context of the violent statements she had been making concerning Cameron in particular, but also just in general, some of the negative things that she had said, it is not unreasonable to think that she had a plan for doing something later in the week.
Okay, or, actually, and I appreciate you coming back to me. Does her statement, a statement of to blow up the school, is that enough?
No.
Okay.
I think you have to consider the total circumstances. Context matters here. You have to look at the totality of the circumstances, the context in which that statement was made.
All right, so if that on its own isn't enough, do we have to have a more specific statement of how she's going to blow it up? In this case, it was douse the school with gasoline.
No, I don't think you have to have a more specific statement of how you were going to blow up the school. It happens to be the case that here we do have a more specific statement, but I don't think that that is necessary. If a student or anyone, student or non-student alike, someone on school grounds makes the statement that people hear, that they are going to blow up the school, I think that is sufficient for the school to do what it needs to investigate whether there is a true threat here, and for us to determine whether that was criminal conduct. So, Your Honor, Your Honors, I think in the light most favorable to the state is there is sufficient evidence that Sophie made the statement that she intended the statement to be heard. In fact, multiple hearers of the statement that she intended to blow up, or that she was going to blow up the school. She was going to use the school in gasoline and blow it up. There were, in fact, hearers of this statement. Someone, at least one person, was concerned enough to have taken this administration, school administration, and law enforcement certainly this threat seriously, and did what it needed to do immediately to discern whether there was any reason to think that this was going to happen on Friday. So there is sufficient evidence that it was heard, that, and I think the juvenile, again, has stated time and time again that no one took this seriously. Well, that's just not the case. It was taken seriously by several actors, and moreover, there was not consensus by the students that heard that it was mere joke. At least one student testified that he thought, but Madison and Caleb testified that she might have been joking, she might have been serious. Again, these are 11-year-olds testifying in court about what was in the head of Sophie, who made statements. I think it's very hard to look at, to try to determine her subjective intent without looking at some of the objective factors, which include the fact that she said this loud enough for everyone to hear. I think other objective factors must be considered. The fact that Sophie said this was not something she had said before. Now, she admits that she made violent statements in the past about other things, but she had never made this alarming statement about bombing the school until this day in September of 19.
I'm just trying to this statute, does a reasonable person have to be an adult? Because I could see two 5-year-olds and one says the other one, I'm going to bring a laser gun in this school and shoot up everybody. And another 5-year-old might think, that's going to really happen. I mean, because that's what they would think. But if that got reported to the principal would know that that's just is fantastical. So it wouldn't be a violation of the statutes. I'm just trying to wrap my head around, is it the reasonableness of what an administrator would think? Is this a real threat to the school? Or would an adult really take this seriously? I'm not saying that the state didn't prove that. I'm just trying to give and what the thought, is that really relevant or not? Or we look at what was indicated. Would an adult have taken that seriously? The administrators and the teachers take that seriously? Because I think the two 5-year-olds, that wouldn't be a violation of the statute, because it would be what administrator. Otherwise, that 5-year-old's committed this crime if it's the test. So I'm trying to figure out what the test is as far as the receiver. I mean, she might not communicate it directly to the administrator, but I guess it's reasonable to assume that if you make this statement, it's going to get reported up the chain, I guess. And so I'm just trying to think if it was meant to apply.
Right, Your Honor. As you point out, as you are well aware, this statute 14-277.6 does speak to doesn't speak to subjective or objective intent. Now, when we're talking about the communicating a threat statute, it specifically sets forth elements. And so we are working from, precedent and case law from the Supreme Court and from this court in Taylor. And so there's some discussion cases about the or the hearer of in those or of the statements, the alleged threats in those cases, but there's no definitive answer to the question we're talking about, or whether, when considering whether the objective test has been met, we're talking about a reasonable objective adult or reasonable objective of the age of the actual listener here. But I would submit that in this case, regardless of whether we're talking about a adult or a reasonable child, and a reasonable 11-year-old, a reasonable middle school age person, the threat that the statement that the school, I'm going to douse the school in alcohol, gasoline, and is objectively threatening to anyone who might be at the school, be it an adult or a child. So in this case, I think the state presents sufficient evidence of the objectively threatening of that statement.
Yeah, and I'm trying to parse this. Then the subjective part is, did she have to say the statement in a way that it would have been communicated up the chain, or is it just enough to violate the statute if you just tell another person and you only intended to tell that other person, hey, I'm going to blow up the school Friday, and the other person would be an 11-year-old?
I mean, the statute speaks to communication, person or group of persons. And certainly here, it was communicated, the threat itself was communicated directly to the middle school age students who heard it. That threat was also eventually communicated to the administrator, both of whom could have objectively found the statement to be an act of mass violence at the school property.
You got 4 minutes, so talk about the threat to Cameron.
Yes, the second statute at issue and the second statement at issue is 14-277.1, which is simply communicating a threat, and that is a misdemeanor offense, and that statute provides the part that if a person willfully threatens to physically injure a person, and that threat is communicated to the other person orally, in writing, or by any other means, and the threat is made in a manner and under circumstances which would cause a reasonable person to believe that the threat is likely to be carried out, and the threatened person believes that the threat will be carried out, then the person is guilty of that misdemeanor. And the statement that Sophie made in this case is that she was going to hit Cameron in the head with a crowbar. And again, when the juvenile takes issue with the state's with respect, the threat was made under circumstances which a reasonable person would believe, and whether the threat was made, whether the person Cameron believed that it out. And again, Your Honors, I would say that you have to look at the entirety of the circumstances here, the totality of the circumstances here. It was certainly, there's ample evidence in the record, both from the adjudication, that Cameron believed that Sophie was both capable and willing to carry.
At least hitting them over the head with a crowbar. Maybe not burying them, but I don't know. At least that part of it.
I believe his testimony was that given her size and height, it would be easy for her to overcome him and carry out this threat.
Okay.
So, and it has to be that reasonable person would believe she would both hit him on the head with a crowbar and put him in a shallow grave, right? It's the whole threat.
Well, I think the injury part of the threat is hitting you in the head with a crowbar.
That's all what we're looking at? Because it seems to me it might injure somebody to put them in a shallow grave.
Certainly, but hitting someone in the head with a crowbar certainly satisfies that portion of the statute that requires
so we
that.
can parse them out?
I think you can. I think that the first part of the statement is enough. If she had gone on to say something along the lines of, after I put him in the shallow grave, I'm going to burn his body. I mean, I don't think you need to get to that part of the statement to analyze whether the first part of the statement is a threat that a reasonable person, and in fact, this case, the hearer of the threat, was whether to believe that threat would be carried out.
So we only have to determine whether he thought it was reasonable or an objective person would think it was reasonable about the crowbar, and we just.
No,
Doesn't the shallow grave give you some sort of context? Because that's a lot more or less likely, if that's a way to say something, than hitting somebody on the head with a crowbar.
I do think that that is a relevant piece of evidence that the trial court considered in determining whether this threat was objectively and subjectively whether it was objectively a threat and subjectively a threat, whether it satisfied both tests. I do think that that was a relevant piece of evidence. I simply intended to communicate the hitting over the head with a crowbar is a sufficiently injurious proposition that it satisfies the language of the statute.
So from the evidence in the record that these threats have been going on for a period of weeks, at what point did the school become aware of these threats and the bullying of this child?
It appears that administration became aware of the threat on 4th, 2019. There was some evidence in the record that a teacher had been made aware of comments made by Sophie previously, but there's no evidence in the record that that escalated to school administration or law enforcement.
Does that support the juvenile's contention then that the school took it seriously, the teacher knew about it in advance and on the information for which the teacher was aware?
I don't think it does, Your Honor. There's a school administration certainly is tasked with following up on incidents of this nature. And, you know, it doesn't reflect favorably that if such statements had been made to a teacher and the teacher did not follow up on it in an appropriate manner. But I don't think it gives any to that the school did not seriously, because once administration of the threat, it reacted promptly, immediately, and appropriately. We would.
Spend a minute. I'll give you to wrap up.
Thank you, Your Honor. I was out of time.
But you can spend a minute to wrap up since we interrupted you.
No, thank you. So, Your Honors, I simply want to conclude by saying although this court held in Taylor that the test is both an objective test and subjective intent test, as the court is aware, the state has appealed that for the state Supreme Court. But regardless of what the test stands, the state would submit that in this case, ample evidence presented to the trial court judge that both tests were met. Both statements at issue in this matter were objectively threatening and reasons, we respectfully that this court affirm the trial court's adjudication order.
Is that case of Supreme Court, has that been argued? Do you know?
It has, Your Honor. It was argued on March 24th.
Okay, so decision pending sometimes. Okay.
That's right.
Thank you.
Thank you.
Thank you. You have 5 minutes for rebuttal.
May it please the court. I want to respond in part to what both this court and the state have suggested is the most damaging evidence, which is Sophie's admissions. And those admissions, according to the state and the principal, the vice principal, were that she was going to douse the school and she was going to bomb the school. And her testimony, she was talking about these things, not so much that she directly was making a threat. And that's at transcript pages 111 to 113, and it's worth reviewing what she said. I also attention to the juvenile petition matter, which specifically states that Sophie said she was going to blow up the school. The state didn't have to prove that she said she was going to douse the school in gasoline, and they didn't have to prove that she was going to bomb it based on the petition that was filed. They had to prove she was going to blow up the school, and when the most damaging evidence appears to be something else, I think that says something about the case that the state presented here. Again, going back to the context, the state says the context is important, and it says juveniles might have forgotten what happened in the year that past education was pending. I recognize that COVID delayed this case, but the state bore the burden here. They bore the burden of proving that Sophie was delinquent, and they bore the burden of proving that this speech was unprotected. They failed to provide the context, and it was their responsibility. They asked leading questions of the witnesses. They did not provide that context. So to the extent that the context is lacking, that's the fault of the state. That is how they did not meet their burden in this case. And that is the argument being made by the juvenile, that based on what was presented here, these were not true threats. The statutory elements of communicating a threat were not met. And I'd like to also talk briefly about the vice principal's notes. As you will see in the transcript, there was a discussion of these notes and how they could be used. There was specifically an objection based on hearsay. This is not substantive evidence of what these other juveniles said at the time. It was hearsay. The judge understood that at the trial level. At most, Sophie's statements in those notes can be used against her, but she never adopted those statements, and I think that's something that this court can consider. I want to go back to Lynn's questions about a reasonable person and how that applies when there's juveniles. And I agree that there's a lot of guidance here, but I do think you cannot look at a reasonable child in this context. And particularly when we're talking about Cameron, he was not reasonable. He believed Sophie could dig up somebody who had died from Ebola, push him into the grave, and cause him to get that disease. And he testified he believed that threat. And we know that as a reasonable person hearing that threat, difficult threat to carry out. It would be a difficult threat for an adult to carry out, let alone an 11-year-old child. So I don't think we can take a reasonable 11-year-old, because I honestly don't believe reasonable 11-year-olds really exist. They're not miniature adults. They don't have the ability to go back and look at something. So Cameron may have believed that Sophie was capable of hitting him with a crowbar, and may have believed that she could do that. But what the statute requires is that he believed that her threat will be carried out. And I don't believe his testimony, even in the light most favorable to the state, went that far. He said she never physically hurt him, and a number of the things that she says that are mean about Cameron are not communicated to him. We have in the record.
I have a quick question. So we talked about a petition that alleges she was going to blow up the school. That's it. That's all it alleges. Can we anything else as the statement that was made, the gasoline, the bomb, anything else, or is it just this statement that was in there?
I think the state has to prove that statement. I think you can consider the other statements when considering if the evidence that she made a statement about the school blowing up was a true threat. And just to touch again on the other petition, since Your Honor, if I could have just 1 minute to quickly
Go ahead,
wrap
that's
up.
fine.
Since Your Honor asked about whether they had to prove both she would hit Cameron with a crowbar and bury him in a shallow grave, that is what the petition alleges by doing both of those things. So I believe the state had to prove both that he believed she would hit the crowbar and bury him in a shallow grave. So for the reasons stated here and in the brief, I would again ask that this court vacate the adjudications. Thank you.
Thank you all so much for your arguments. We will take this under advisement.
Apologize for my
And thank you all for accommodating. Sorry that we were a little bit late doing this. So, ready to adjourn court?
All rise. Session of the North Carolina Court of Appeals is now adjourned.